you need to wear batik. Okay? So it's a custom. But is this international customary law? Yeah? So it's not. And it's not because there's a number of things. It doesn't involve states. There's no juris opinions as well that you respect it because of obligations of the states, etc. But it's difficult also to prove. But international customary law has been evolving over a number of years that allow the customary practices to be incorporated internationally. That is the second source. And the third is the provisions which are provided in 59. They are also of the International Court of Justice. Is that there are judicial decisions, in other words, adjudication case law that have been in the past applied by the International Court of Justice, as well as the expert opinion and the decision by academics or scholars involved in this work. Now, students' essay on international public law, unfortunately, are not yet part of international law. But if you make it to a professor and you publish well-advanced opinion, maybe one day your opinion will be also sold in international law. Now, let's take these ones one by one. The treaties. When we talk about treaties or conventions, what are they actually? Well, they are, that can be done in different forms, we said. It could be convention, agreement, covenant, protocols, or simply an exchange of notes if they are not binding on member states. So there is a variety of ways in which states can regulate their international relationship between the law. But they themselves have a set of rules that govern the drafting and the implementation and the interpretation of treaties. Because clearly when you have a number of provision in the treaty, there might be differences or disagreements about what is interpreted in one particular way. One state might have one interpretation compared to other states. And there, the law of the treaties are set out in 1969 Vienna Convention on the law of treaties, which contains the basic principle of the law of treaties, the procedures of how treaties become binding and how they enter into force, the consequences if the treaties are breached, and also the principle of interpreting treaties. So clearly, when you have, as a lawyer or a student of law, and you are looking at a treaty between Indonesia and, let's say, China on some territories, and you have some older treaties that have been signed between the treaties. If you have a dispute on that matter, your guiding Quran on this part is the Vienna Convention, 1969. Then you must have a copy with you as part of your reference material at your desk or your electronic version. Keep that on your website, on your desktop. That it allows you to interpret, to understand, very useful document, actually, a source to understand international law. I think this is very useful. It's also one point I mentioned earlier that one of the sources of international law is international customary law, which means it's something that has been implemented but has never been actually codified as such. But there is also certain conventions or covenants. A convention is something that, for example, on the international environment law now, it's not yet drafted as a treaty and being implemented. There is an agreement about it, but it's not yet, because we know there is a process for it to become a treaty. That treaty, there is a procedure for it to be adopted, ratified by member states, parliaments, and transcribed into procedures for implementation work. So, in fact, the International Convention, the Vienna Convention on Law of Treaty, is actually a good example of international customary law. Because when it was adopted, it was just a covenant or a convention. And that's still called the convention, it's not called the treaty. And it was never developed into, through all the stages of the adoption of the treaty, conscription by national government and putting procedures. It was simply adopted by a large number of countries who never actually signed to it. It just became, that's the best practice there is. People applied it, and then it became the source of international law. So the sources of customary law is a very, very important part of the interpretation, and also the source of well-governed international economic relations in the United States. Is the so-called pacta sunt servanda, which simply means that every treaty in force is binding on the parties that have signed it, and it must be performed in good faith. This is a good principle, is that if you sign an agreement and a treaty, or convention as we want to, depending on terminology we're using, you must act in good faith. You have to realize that it's binding and you must act in good faith. And because otherwise, in other words, you need to have trust in that treaty. Because if countries cannot trust each other, you can sign all kinds of paper, but they won't even know the paper on which they sign if you cannot trust whether the person will implement that treaty. And in fact, this is something that often comes out as criticism of the international organizations, including the UN, that many of the resolutions, many of the decisions, of course they are not treaties, but they are General Assembly resolutions, normed by this, and have not been implemented. Countries come out, make all kinds of promises and commitments, but unfortunately they go back home and act differently. And this clearly undermines the trust and the confidence and the reputation of the United Nations and its functioning international system, because they are not implemented by the member state as such. It is also possible that the treaties don't have to include all universal memberships. Treaties can include only the countries that would like to sign these treaties, and treaties can be open for other countries to join and ratify as they feel when they are ready. That's very important. It's not necessarily universal. And the reason, I mean, as an example, I would say is, if you look at, you have regional, the South Asian Association of Southeast Asian Nations, having agreed on a number, for example, establishing the ASEAN Economic Community, it's a regional treaty, and other component for it. The negotiation right now between New Zealand, Australia, ASEAN countries, or individual. So treaties can be bilateral, can be multilateral, and can be also regional. And one of the difficulty, however, with some of the regions is that you can have overlapping memberships. Is that Indonesia is not only a member of ASEAN, but it's also a member of APEC. It's also a member of NAFTA. It's also a member of the United Nations, which is a member of everything. It's member of the WTO. So sometimes, and when the commitments are overlapping, or sometimes contradictory commitments, it's undermining the smooth operation of international economic relations as such. Customary law, I just want to draw attention to you that a very important feature for customs practiced by the states in the conduct of business and relations with other states, to become international customary, you have to have opinio juris, okay? Which simply means, but this is something extremely difficult to establish, because it shows that countries has followed a particular practice not out of interest or as a courtesy to some other country, but it is as a kind of obligation, as legal obligations. So if you are a lawyer and you want to prove that the other party who denied that this is not part of international customary law, is how to actually prove that this was a juris obligis. That's the element. Now, it's important to get a little bit into the details, because I mentioned to you that the international economic order, which is made out of, as we said, the Bretton Woods Institution, the UN, and the rest, has to have some basic principles. And those are actually defined in the Charter of the United Nations. Remember that we talked about sovereignty. If we say that countries are sovereign, and only the country itself, and the government and state, has the sole and absolute authority over this territory, it means that no other country can encroach on that sovereignty, whether it's financially, politically, or militarily. And you can see this principle is the basis for peace and security. You want your neighbor to respect your territory, your citizens, and you do the same. And for that you have to have responsibility and obligation as a state. So this is why in the Charter, this principle, they are wanting to avoid war, because usually if you don't respect me and you attack my citizens, I'm going to attack you. And that's how war starts, okay? Or if my investors are in your country and you attack their businesses, like last night in Nigeria, because, well, first in South Africa, businesses owned by Nigerians were attacked by South Africans. A lot of people, stock market was burned, stolen, and so on. Nigeria did exactly the same to South Africa in their own country. And this is how the issue of dispute between states. In some other countries, I think in 1976 or 77, Ecuador and Peru went to war. For what? Football match. Football match. Supporters of one country were attacked, beaten, people badly injured than the others. But instead of solving the issue of the individuals who were responsible, it inflamed and became war between countries. So you can see that this issue can, oh, by the way, I saw there was some problem between Indonesia and Malaysia yesterday.
Yes.
So football match. But I'm sure that will not lead to war. It's just a dispute between supporters. Now, I have there that some of the principles and the General Resolution 2625 that states should refrain from use of force against the territory and the territory political independence of other countries. Well, you know that this is not. Many countries have seen their territory invaded by other countries. Many countries have seen their election being manipulated, including through votes and Facebook and etc. in order to hold the elections. So unfortunately that basic principle is not respected. The pacific settlement of disputes, in other words, if there is a dispute between countries, it should be settled in a peaceful manner. Non-intervention in matters within the domestic jurisdiction of any states, according with the Charter. Cooperation with one another in the specific as outlined in Charter. Equal rights and self-determination of peoples. Sovereign equality of states. And that the states should all fulfill this obligation in good faith. The factor. So those, I think it's very important to remember that those are the fundamental principles on which international economic order is based. Now, I want to remind this, but remember, they're useful. For example, if you're talking about globalization, or you talk about that the environment, that the world environment is being destroyed. There was a fire in Amazon last week. It affects the whole world. And the question is this an issue only of Brazil? Or is it all of us, humanity? Now, clearly, it's a Brazilian territory, but we know the Amazon is not only in Brazil. It's in Paraguay, it's in Ecuador, it's in Colombia, up to Costa Rica, etc. All those countries have the Amazon. And therefore, if there is a dispute about whether we should burn the Amazon to produce plantations for soya beans or, I don't know, ethanol, what have you, or should we use it for future generation and the rest. So clearly this is one example where the basic principles of international law can help us at least find a solution to international economic law. So international law principles on which the international economic order is set up can help us understand and find solutions to the international economic problem. As I said, for environment. But if we have problem with refugees, millions of people, because of war, are moving. We also have international charter about the protection of refugees. They have rights and so on and so forth. If we have problems with minority tribal groups in Indonesia, which are losing their livelihood because their environment will be destroyed, we also have a way to resolve these problems involved in this. If we have problems of unemployment and poverty around the world, we also have the same principles will allow us to understand this issue. If women are subject to discrimination, to violence, I was really surprised yesterday that in Europe, every year, this year alone, 157 women were killed in France. And the year is not finished. Killed, 157, by whom? By their husband, boyfriend, or family members. And there were more in Germany, and as many in Spain, etc. This is the statistic that was reported on Euronews yesterday on the rest. So the question is that why are individuals of their own groups are victimized or subject to this violence, including losing their life? So there again, I think we have principles which are available in law, in charters, in agreements, and we should try to use them to understand what the problem is and find solutions which are based in this process. Here again, I think it's the charter also talks about the responsibility of states. If the state did something wrong, the charter also provides ways of how that wrong can be repaired. So there could be damages or compensation for those who are addressed. Can you think of an example that is still a dispute here? Very briefly, as you've seen, Japan and Korea are almost at war now. I mean, political and economic war. For one, because exactly this principle. Korea accused Japan of wrongful conduct, an act during the Second War, and they have not been in reparations. And the international law principles, if you apply this is what Korea is saying. We have a principle that if you did something wrong, you must repent. You have to do it. Well, Japan says, yes, we did. Korea says, we're not satisfied with this. And you can see that maybe instead of what's going on now, if they had applied the UN Charter, it would have been much easier to settle the dispute in amicable manner rather than get into tit for tat. Now, of course, the state has jurisdictions. In other words, they have the ability, the power to apply the laws. If you have somebody, I mean, you can rely, what you said so forth, is that if we have an international dispute, we need to cooperate with others. But what this thing says, jurisdiction, means that you can apply your own law. For example, if somebody from a foreign country commit a crime in Indonesia, you can apply Indonesian law. Okay? That's what it means by jurisdictions for citizens. If there is a terrorist group which commits a crime here, or does anything that is prohibited by law, then the state has jurisdiction to apply this particular law. And it doesn't need cooperation with the other state. It might need to exchange information, respect due process, but for that, even if the person is foreign, you can apply your national law in your own countries. Okay, let me move now. One thing which is, I think I wanted to mention, because I see I'm running out of time, but I want to still complete what I'm doing, is that when you have a treaty on a contract, you have to always anticipate, what if there is a dispute? We need a way to resolve that system. And for that reason, the international, the main judicial organ of the United Nations is the National Court of Justice, which I said right from the beginning that early the state have access to this particular decision. Okay. The next slides give you the role, what interpretation, what is the scope, because it applies customary law. So it's the National Court of Justice that determine whether the claimed conduct is under what are the sources, the treaty, and if it is, how to interpret that treaty using the convention, Vienna Convention, or if it is customary law, look at the criteria and determine the case and jurisprudence as such, or it might look at academics and other research. But it also has an important role that it has when the Security Council has some dispute. For example, about whether the war in Iraq is legal or illegal, or whether the evidence is supported or not, it can actually seek a legal opinion from the International Court of Justice in order to explain. If there is a genocide case, or maybe it's not a genocide case, maybe it's a civil war, we don't know. So the Security Council and the General Assembly may actually ask the court for an opinion on which it can base its own decision. Now, when we move now from the legal part and we look at the economic institutions, I want just to mention to you that one of the commercial international business transactions is mainly regulated by UNCITRAL, which is the United Nations Commission on International Trade Law, established I think in 1966. And its main role is in the adoption of national legislations to improve, to harmonize, and to converge national laws that facilitate international business transaction. There could be investment, there could be trade, and under the Commission, actually, it has a number of working groups. There is a working group on small and medium enterprises. There is a working group on e-commerce. There is a commercial group on, I think it's there's one on dispute resolutions, etc. So you do have a whole series of working groups that provide international commercial transactions. The other, and I really have to move fast because I know you have other classes to go to, but at least I want to cover, and you can take the PowerPoint afterwards, is the international, the World Trade Organization. I said international because after the Second World War, the idea was to create International Trade Organization, ITU. But that, unfortunately, the US refused to, and lived on through the interim GATT arrangement, and later on become the International Trade Organization. And the main agreement, as you can see, is a large of them, is the WTO agreement, the GATT agreement, the agreement on agriculture, sanitary and phytosanitaries, technical barriers to trade, trade-related investment, implementation of Article 6 on GATT dealing with anti-dumping, the agreement on subsidies and countervailing measures, agreement to safeguards, agreement on trade services, TRIPS, that is intellectual property related, and of course the government procurement agreement, which is unilateral with human countries. So you see, if you want to specialize in international economic law, you have a whole field to choose from to look at. The main functions of the WTO, since there are agreements, so its primary function is to negotiate new treaties that liberalize further trade, and it has not been successful in doing that. But it also has a system for settling disputes among member states through the WTO dispute settlement mechanisms. One thing, and then of course countries might retaliate against each other, and in order to manage and lead this retaliation in sort of measured way, in a way that doesn't become total war. Unfortunately, it looks like WTO at the moment has failed, because the United States seem to have lost faith in WTO and seem to want to go outside. I personally hope that this is just a temporary setback and that things will improve soon. The mechanism for dispute settlement includes a number of things: mediation, conciliation, arbitrations. But there are also other possibilities for bilateral consultations or recourse to appellate panels, where panels that they hold to issue and study a technical and issue a report on this. Now, the World Bank was the other pillar of the International Development Bank. I think it's very important to keep that the World Bank, which later was a major development finance for developing country, was not designed for developing countries. It was there to build Germany, France, Italy, UK after the war. And the American added to it the Marshall Plan that allowed the countries to develop. Now here you have a list of functions, but these functions were not static. They have evolved. The World Bank changed its function, emphasis from poverty reduction to infrastructure, technology, etc. That we move fast before everybody hits the lecture. The International Monetary Fund has a slightly different set of functions, which is to perform the credit to member states. Remember that all currency after the Second World War was collapsed. So the idea was to re-establish currencies, to allow to give balance of payment loans for countries, and allow adjustment and stability of the international financial system, and of course advisory opinion on how to manage the international financial system. One last thing that I think is also important: international investment is a very important part in the past, but today as well. And there are disputes not only in trade, but there are disputes among the state on investment. And what the International Commission has agreed was to adopt the Convention on the settlement of investment disputes between states, of nationals and others. And later on, under the World Bank, set up the Center for Dispute Settlement Mechanism, the ICSID. What it does actually is arbitrate and reconcile dispute among the states in a objective manner. But this, of course, has been based on the old bilateral investment treaties. The new, for those who attended yesterday's class, we talked about new generation of international trade investment, trade and investment treaties. And the new generation of international investment treaties are more complex. And the proposal now actually is for enterprises to be able to sue, to have legal personality in international law directly, which we know, as I explained to you in the beginning of this lecture, that private and multinational companies do not have legal standing in international law. But this is already happening in some bilateral investment. Just give you two examples that are going right now. France was going to build a nuclear facility, but because of the pressure and the investment and the social group, it was considered unsafe to continue with the project. So the government scrapped the project of nuclear. Now, of course, before they reach this stage, a number of multinationals have bid for the project, did research, and started doing the preparatory work for this. Those companies today are suing the French government for breach of contracts and asking for compensation. And this is a very controversial issue. How far can legitimate protection of investment go? How do you reconcile it with national objective, with the democracy? If people, for example, if democratically everybody in this country said, we don't want nuclear factories in our country anymore, because we know new scientific work has shown, how do you reconcile that with protecting the risk and who should pay for it, etc. So let me stop here, because before I will be speaking in the anteroom. I understand if you have other obligations and other classes, and please, if you have any questions, I will be here, and I'll stay here longer.
Yeah, please.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad. I want to ask several questions regarding trade war between the United States and the Republic of China. First, why it happened, and second, how it could affect the international community, and how should we embrace for the outcome.
Thank you very much. It's a very important question. It will require me a couple of hours to answer this. But the good news is I gave a talk on this, and I have a PowerPoint presentation. I think Ola has a copy, but I also have a copy. So you want to write to me or ask Ola if he has a copy. We have a very detailed explanation of why, or what is at stake between the United States and China. But I would say very briefly that it is a trade war, but trade war is only the top of the iceberg, meaning it's only the front explanation. But what's behind it is a political security and a fight about supremacy in the world. China grows very fast over the last 20 years. If you look at the rate of growth of the average income of Chinese or industry or external asset, China was low. I would say it was, in terms of per capita income, it was below Indonesia. If you look at late 70s, early 80s. But today, clearly it's number 2 of the economy. But it also has been able not only to grow economically, but it has also adopted a very aggressive geopolitical strategy, dispute about territories in all Southeast Asia, with almost every country. With China, with Japan, with Indonesia, with Malaysia, with Philippines, with Benin, with Philippines, with everybody there is a dispute on this. It also claimed territories, islands that were just uninhabited, and it built military bases on them in Southeast Asia. So the United States see this with alarm. So there is this political geo-security that the rise in economic power is now leading to the rise of military power. China, and it's also changing the balance of power and the relationship of the US had with its traditional partner in the Philippines, in Indonesia, in Malaysia, in Southeast Asia, as such. So, because of this issue and the implication for the rest of the world, for the US perspective, the US decided that we need now under the current administration, we need to contain China. And we need to contain China very aggressively, because it doesn't mean that Obama or Clinton did not contain China. They did, but they did it more discreetly through different means. By allowing China to become member of WTO. By allowing China to become member of WTO, they thought China will become a market economy. But China didn't become a market economy. On the contrary, they used WTO as openness to trade with the rest of the world to strengthen the economy and the Communist Party power. And this is now viewed as a threat. So, I'm not taking side, I'm not saying who's right or wrong, but I'm saying from what the statement of the foreign policy, the brief foreign policy, which I mentioned in the lecture, we'll have the references there, basically to put a brake on the Chinese economic development plan. In other words, to slow their economic growth, to slow their expansion of export, to close markets where they can export, particularly the United States, and force EU and friends of the United States not to do business with China. One example, Huawei, which is the most advanced company in the world in G5 technology. And you know, everybody is migrating to G5 technology and say, no, no, no. GY is belong to a Communist Party member, and they are and they are spying for the Communist Party. And if you use that technology, you lose your sovereignty, etc. So don't do business with them. Australia, New Zealand, EU countries are not sure about this. UK has decided still to do business with them. So the idea is this, is to block their companies from growth, from having market, etc., and therefore allow your business to grow this, and at the same time reduce the speed at which China is growing and contain that economic growth, therefore containing economic power, and therefore disrupting their strategy. For example, the Silk Road, the Road to Build initiative that includes all the ASEAN and Europe. So that's exactly what's behind. But what we see is only the facade, tariffs, another tariff, retaliation, another 50 billion tariff, another 15 increase, and so on and so forth. But what's behind it is far deeper concern. It's concern about the shift in political power between the US is losing that power, and the US also has its side to blame, because the US is being withdrawing from world leadership. G7 meeting in Paris, for the third time, the US refused to say a declaration. So I think that's my answer to the first question. And then your second question was?
How it could affect the international community.
The effects. Well, clearly, because I mean, as we know, the world we live in is an interdependent economy. Meaning that China depends. How did China grow? Because it was exporting, and exporting to whom? To Europe, to ASEAN, to United States. And not only exporting, but it was producing. Where did it produce all its goods? Most of them are producing in factories in ASEAN. And where did it get the technology? It get the technology from the US, from EU, from other companies. So clearly, an example is about a year ago, Trump decided that Huawei was a threat to the US and should be sanctioned. And remember what he did? He prohibited them from he prohibited the American company from Qualcomm to produce the processor to sell them to Huawei. And you know what happened within 24 hours? The company says it went bankrupt. But immediately the American companies, Qualcomm, wants to to American president says, Mr. President, we're going to close business as well. Because the biggest buyer, our biggest client is China. You see? So it's the whole world is independent. That's one answer. That China itself depends on technology, and US also depends on technology. But it's the world. China doesn't only deal with US. A large number of technology and markets are in Europe. So if China cannot produce telephones, it cannot sell them to Germany and Europe. That's the first. But many of the technology that the Chinese use are bought from Germany, from France, from Nokia, from other European countries. So if China's economic growth falls and factories are closing down, they will not buy technology and products from Europe. Okay? And if they cannot sell their television set, their fridges, their Lenovo, their computers, which are, where are they produced? They are produced in ASEAN. So if they cannot sell them, they're going to close the factories in ASEAN. So you see, the whole world is, I would say, interdependent. You know, once somebody catches a cold, the whole, or sneeze, the whole country that are working with us. Exactly. That's one of the big feature of globalization. When everything goes well, everything goes well. We're all well because everything goes up. But one thing goes down, the ground spiral goes down and down for everything. But we have to be also modify what I'm saying. Is that not all countries are involved deeply with China to the same extent. For example, Indonesia, among all the ASEAN countries, is the most insulated because there are less Chinese factories in Indonesia than there are in Thailand or in the Philippines or Vietnam. So I saw some recent statistics that's been published by the Asian Development Bank and listed the countries that are mostly affected right now. Now, of course, maybe in the long run, some pipeline projects that are developing with China might be Indonesia. But at the moment, in terms of the global value chains, the factories that are owned by Chinese made for exports in Indonesia under the Chinese name are very small. And therefore, Indonesia's impact of China's construction will be limited. But if China overall is facing financial difficulties, it has less money for investment growth. And any investment project and plan that it had for Indonesia would be revised, either reduced by half or even cancelled as such. So I would say that at the end, everybody loses from this trade war. Because it's one, you know, you think about the world as one market. So if the major traders are not selling and the less customer come in, everybody in the room suffers. Of course, some might suffer more than others. In other words, the distribution of the cost will be different, but there will be costs for everybody.
Any other questions?
Good morning. I have a question. I attended your public lecture yesterday as well, and I have a question that I didn't get the chance to ask. It's about what you said regarding global value chains and how regulations play a part in leveling the playing field for developing countries against other dominant parties who monopolize international trade. But still, the benefits of the global value chain and international law in general are not evenly distributed. I remember you saying that to solve the problem, there needs to be a reform on the WTO, and Indonesia needs to be proactive about WTO's reform. What I'm confused about is what could Indonesia possibly gain, and what could Indonesia and other developing countries like Indonesia could possibly gain out of the reform of the WTO.
Okay. Well, thank you. It's very simple. First part of your question relates to global value chains. And I said that the global value chains providing excellent opportunities for developing countries, including Indonesia, to climb up the ladder into value and produce goods that create higher income, that pay better wages, better salaries, make the country prosper. But I said we have to be careful there, is that there are some challenges. And the challenges is that if we look at the governance, I mentioned governance of the global value chains, said that's mainly covered by multinationals themselves. And their decision, the way the global value chain is owned by a company, on what to produce, where to produce it, and what wages to pay, what profit to repatriate, what technology to transfer for a particular country, determine how much benefit you will get out of this. If you have a company that invests, train local people, and transfer the technology, and pay high wages, and produces a bigger value added of the product in, let's say, Indonesia, the benefit will be much higher than if you are, let's say, in a sector which is low value added, let's say maybe drinks or foods, vegetable processing, which is lower than IT, for example. For that was the one big dimension about that not all global values distribution provide the same equal opportunities for Indonesia and developing countries. That's the first part. The second thing is that the nature of the relation, the commercial transactions, and the dealing of the within the governance of the global value chains between companies, which are the owner, and the subcontracting companies in developing countries, including Indonesia, is a question that depends about what is its market structure. Because if you face a monopolization or a dominant position upstream facing a downstream, it can lead to possibility of abusive conduct, either as an exclusionary or exploitative in terms of low wages or condition of sales interest. Or it can be in terms of buyer power. If you're depending only on one large buyer outside the world to buy your products, clearly, if you have nobody else who can buy, except you will have to accept a condition under which you have. And we said that this type of relationship here, abuse of dominant position, or potential abuse of dominant position, or abuse of buyer power, which is different from dominance, can be addressed by competition law policy or by regulations. That the government will have to regulate those contacts and find a way it can be done. That's how it's been done. Now, how do we link this to WTO? We say that the WTO at the moment, there are a number of complaints or grievances of developing countries about why the international trading system by itself is lopsided. In other words, there have been, I mentioned some great benefits in the liberalization of goods, but when you look at which sector liberalization took place, you see there's mainly those sectors which are favorable for developed countries, not for developing countries. So already that aspect where which sector we negotiate on is an area that will be of interest to developing countries. What are the areas that, for example, would be interesting for developing countries? Developing countries are rich in labor. Okay? And if Indonesia wants to negotiate with other developing countries, it says, why can't you make free movements of Indonesian students, free, for example, free education, because your EU and United States give billions of aid. So instead of giving billions of aid that end up in corrupt pockets, why not give free education to top students to study in top universities? That's one thing, as part of free movement for education. But there might be also a lot of people in Indonesia who are technicians, nurses, doctors, engineers, constructions, etc., who want to work, let's say in Europe, Australia, or Japan, or United States. Not to migrate, There's nothing bad in own homes, but just to work there, start a business, learn technology, earn money, come back home. Go a month, 6 weeks. Why can't we allow a liberalization of temporary movement of labor as provider of services in the country? This will be of great benefit because it will create jobs. It will allow people to have high income, support their families, buy homes, start businesses, etc. This will be an idea. So this sector of labor movements, for example, where we're talking about services, modes of delivery, to live in your country, but to travel to other countries, to study, to travel to other countries, to sell products, to provide services to the rest. That movement in the service sector will be highly beneficial for Indonesia and developing countries, because that's a critical area. Developing countries, including Indonesia, produce agricultural products, tropical products, processed, but those sectors are not liberalized. The markets are closed. So there will be another area where there could be an issue, where the selection of the topic would be put for benefit. But come back to what I said about monopolization and abuse of dominance, and that is the relationship between business to business. Those are not subject to WTO agreement. As you know, I hope this was clear from the discussion, that the WTO agreement only regulates relationship between states. So when a private company engages in a cartel or abuse of dominance or abuse of buyer power vis-a-vis another commercial transaction, it's not the subject of WTO or international treaty. It isn't. It could be, but it isn't. So one possibility would be to put competition, control of abuse of market power, of monopolization, of cartel, of abuse of competition under an international treaty that is governed within WTO. So that type of agreement would protect developing countries. Because if you had an international cartel located abroad, making an agreement and dividing, let's say, 3 companies based in some island, or in Australia, for example, or Japan, or Korea, they say, okay, we're going to divide ASEAN into 2 regions. You take region 1, you take region 3, and I take 3. And we divide them. And we charge the prices we want and the conditional terms we want. What can you do? What can PPPU do on this if they are located? Without the cooperation, without international binding agreement on this? Nothing. Or almost nothing. There are a few things you can do, but it's very little that can be done on this. So clearly there, a reform of WTO that includes the scope of the topics to be covered under negotiations. What specifically? Those sectors that are of interest that will benefit the growth and economic development or give a fair share to developing countries. For example, agriculture, semi-manufactured goods, and also in services, labor movement to allow people to study and to provide and work for jobs, etc. This would be a good example. In the area of regulations, we know that business to business in the world we live in is global value chain. It's the businesses who are driving trade. But they don't just produce goods here and sell them there. They produce them in 3 different countries and they control the whole chain. And therefore, the conduct, that particular business model is subject to the possibility of exploitative or exclusionary conduct. And we need to regulate it. We're not saying we don't want business. We're not saying that dominant firm should not exist. Dominance is okay. It's nothing, no problem with that. It's the abusive conduct. It is the exclusionary conduct. It's the exploitative conduct that lead to unequal distribution of the benefits, and actually it's not in the interest of business. Why? Because people riot against business. They go destroy business because they say, we exploit us, you don't pay. So the law will protect business and will protect the interests of the workers in North and in the South. So I hope that answers the question.
Last question. Yeah.
Assalamualaikum warahmatullahi wabarakatuh. A something for you about what you're practicing about the ASEAN economic growth until 20 years later. Because now ASEAN have a big trade about trade war. Because ASEAN is a big customer for the China market and US market. Thank you.
I'm sorry. Can you please repeat the question? So the question, yeah.
What's your prediction about the ASEAN economic growth until 20 years later?
Or the challenges? Well, a little bit, somehow I responded a little bit to this question, because what I said is that the world is interdependent, and clearly if the world trade, and there's even now talk about the world recession coming up, the financial market says that so-called inversion of the yield curve, that the long-term interest rates suddenly are becoming lower than the short-term, is an indication that people have no confidence in future growth of the economy. So if that doomsday materializes, clearly it will mean that less export, and ASEAN countries we know are export-oriented economies. They've been relying on production and export because they're part of this global value chain, and also their model is to export more and import less. So clearly, if your export markets are shrinking because of the war, because they're closed because of barrier tariff, clearly this will have a negative impact on growth. But I wouldn't, this may be immediate. We know the other advantages also of the global value chain is that if you change the value of the export or of the product, you can also change the rule of origin or classify it under different rule of origin. And the product will escape the tariff that imposed on a particular country. So I wouldn't be surprised if, in reaction to the U.S. tariff on Chinese products, because at the moment it says Chinese-made product. The question is, what is the definition of made? And that, under the WTO, has to meet the rule of origin qualification, which depends on value added. So if China relocate in the medium, because you can't do it overnight, medium to long term, almost a large part of their industries to ASEAN countries, and these products become ASEAN Indonesian or ASEAN Vietnamese, Philippines, etc., they will not face in the United States the same tariff as it is. But you could be sure that the United States have already taken this also into consideration, and we don't know what the consequences will be. So it will certainly mitigate, and the cost will not be equal for all the countries as a group, as such. The third possibility is that China might actually redirect its exports from US to ASEAN. Say, okay, we will reinvest now more in ASEAN. We think ASEAN is a more reliable investment partner than the United States. And since we are talking about particularly technology and the rest, they will identify those sectors which are key for them. So if I was advising the ministry, let's say in Indonesia or any ASEAN country, I say, look at what China's Make in China 25 strategy says. I gave it in this days. It's IT, it's robotic, new technology, all made in China by China. If you have the technology, if you have the skilled staff, you can be a very attractive investment destination. So why not get Indonesia to focus on that sector, invest more, have more research, scientific research between Indonesian universities and academics in China, to identify. In other words, says, look at this as an opportunity. Don't look at it as a negative things. Say, an opportunity never come to your door. Say, excuse me, sir, I'm an opportunity. Please come and invest. You have to spot an opportunity. So if you can interpret this war between the two as an opportunity for ASEAN to emerge as the new destination of Chinese investment, as the new destination, an opportunity for scientific, technological research and cooperation with Chinese university, Chinese ministry, Chinese company in this work. I think this could be one useful way to turn this challenge into an opportunity. And for example, I know that the government is moving the capital, but it's a long project. And yesterday in the Jakarta Post, the president says that the new city will be a modern, highly technological city, which is great. This is the time to work with China and use all the technology, all the research, get all the academics, all scientific, technological universities research in energy, in environment, transport, education, protection of civilian during earthquakes, how to build houses that are strong against earthquakes and so on and so forth. Do the best and planning for the next 1,000 years. That's a great opportunity. I think it's great to involve the Chinese in this and say, well, if the Chinese are not going to the United States, we will do this. Yeah. It's their loss, and their loss is our gain for this. So I would take it as this perspective. Thank you.